Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about legislation that was passed here in Florida that provides the opportunities for electronic wills that will come into law July 1st, 2020. So at the time of this recording, electronic wills are not a available tool for people here in Florida, but we anticipate that we will be able to start preparing and executing wills electronically as of July 1st, 2020. So I wanted to take this opportunity to walk you through it and what it looks like and what we anticipate as practitioners. If this is of interest to you and you want to talk about it further, feel free to set a meeting with me at eldermeeting.com or we can talk about any other elder law probate type topics that are of concern to you or your relatives. So this electronic wills in Florida, effective July 1st, 2020, what the legislature did is it passed laws that says that we can now have people sign and execute their wills through use of video conferencing technology, where a notary could be online and the witnesses can also be remote and online, and everybody does the execution process through the use of video conferencing technology. There are specific rules governing how this will work, specifically that the notary has to have certain types of technology, they have to have certain bonds in place, and they have an obligation, the company that is doing the signing, the notary service, they have an obligation to hold an electronic copy of your document, the video, and deposit that, be a repository and submit that to the court. Some of the things that people anticipate as concerns and problems with when this comes online in July is that the electronic will is not available as an option for people in Florida who are considered vulnerable adults. Vulnerable adults are defined in our Florida statutes as a person that's 18 years old or older, who has whose ability to perform the normal activities of daily living or to provide for their own personal protection is impaired due to mental, emotional, sensory, long-term physical, developmental disability or dysfunction, brain damage, or infirmities of aging. So people who are in this category will not be eligible to engage in an electronic will because there's just super concerns of duress. We just want to make sure that the person that is executing a will is doing so freely and without pressures. So we think in Florida we have a large population of elderly people, and the last thing that we want is for people to be changing up their wills because they're being pressured to do so. And the legislature was concerned that through the use of this video technology that there was more opportunities for mischief in that regard, and they would rather vulnerable adults to be physically present in front of a notary and in front of the two witnesses, so that way it can be determined whether or not they know what they are doing and are doing it freely of their own choosing. The concerns with that is that we anticipate the questionnaire about whether or not you're a vulnerable adult to be something that is done before the recording starts. So there might be like a checkbox questionnaire. The person who would like to participate in an electronic will would just check the box, nope, I'm not a vulnerable adult, and then proceed. and which would then cause opportunities for will contests in the future, where family members would then could challenge the will and say, no, this would be challenging it after your passing. They would say, no, my loved one was a vulnerable adult and they should not have been participating in an electronic signing of their will. So that's of concern. And there's also just the concern that people may be embarrassed, and there might not be trickery involved, but a person who would qualify for as a vulnerable adult might just be embarrassed and not want to say that they're a vulnerable adult. Nobody likes to label themselves, particularly some sort of label that would make you feel less than, even though that person may have, home health aid and other assistance in place, which is perfectly fine and is great and really helpful to them. And that's what makes them be able to succeed and stay home and stay healthy and all these good things. And that has no impact really on their capacity, meaning like they legally know what they're doing, but yet under the statute they are considered vulnerable, and therefore a electronic will was not the appropriate method of them implementing their estate plan. So there's just concerns about vulnerable adults engaging in electronic wills and the opportunity for future will contests, because nobody would like their heirs to be fighting over their legacy. So that's one concern that practitioners have about electronic wills coming online in July 2020. The other concern goes back to the fact that these technology companies, the companies that are going to be engaging in electronic wills and notarization, that's going to be a new industry. And tech has historically, tech companies don't always last long. We know that they're startups and they start out great and they may fizzle and they may not be successful. And we, as practitioners, are concerned what happens if the tech company that did your electronic will goes under. What happens to the data? What happens to the video? What happens to submitting it to court? The other concerns are just ransomware and hacking and all these other things that we know that exist out there. What sort of protections are in place for that, and what does it look like when that happens? It's not so much a concern that it won't happen. It most likely will happen, but what does that look like should that happen and when that happens? These are just all unknowns, and as practitioners, we always are looking out for our clients' best interest, and our goal as attorneys is to be reducing risks. And so therefore, when we look at electronic wills as coming online, we also see great risk, and there's great opportunity, but there's great risk. And so we just want people who are interested in electronic wills to make informed decisions whether or not they want to proceed in this fashion, if that's the best thing for them, or if they will just meet in person with their witnesses and with their notary and do their will signing the old-fashioned way. So there is an opportunity here in the state of Florida for electronic wills as of July 1st, 2020. It's uncharted territory, and we are looking forward to always moving into the future, but we do so with great care, and it's just an opportunity for people that may not be appropriate for everybody. So if your loved one is a person who would, or you are a person who would qualify statutorily as a vulnerable adult, this is not a tool that is recommended for you at this time unless the law changes. I hope that this information has been helpful to you. Like I said, this is all new. It hasn't gone into effect yet. And if it's something that you wanted to talk about or had questions or concerns with, or you have another sort of elder law probate question, you are free to schedule time to connect with me at eldermeeting.com. If this content has been helpful, please like and share with others, and thank you for joining me.